Good afternoon, everyone. Let me give you this little piece about me before I get started. I tell you, I'm nervous. Of course, I've been a Charleston County Magistrate for the last 44 years. I have April 2019, I have to retire. In July of this year, I was in my yard, about a week out, doing some work. I got this telephone call. No, what I did, I went and checked my message on my phone, checked the message, and there's this call from this person just saying, congratulations. Then, congratulations, what? Then I, waited till the end of the message. You're now our Chief Judge of Charleston County. I see, you got to be kidding me. But anyway, I got this unexpected, but I thank God for it and for the Chief Justice is seeing me to place this responsibility on me. Again, I have 44 years, and I was just looking to go on out, just served my time and going out, but I'm here. The magistrates and the municipal judges, all offenses that is booked into the county jail that are scheduled for bond hearing has to come through us by law. Even though there are some offenses by law that we cannot have bond on. There are two in specific, murder and sentence, and that carries life in prison. Every other offense we can set bond or choose not to set bond, dealing with violent offenses. We have two cases that has been signed, I think, as relates to, when we talk about our constitutional right, we're talking about due process, 14th, the 5th and the 8th Amendment, as we're dealing with our rights as citizens to the due process of law. All of us are bound by that. These two cases, because of what we do as judges, these two cases are prime example that has been filed in the courts and have been ruled upon as it relates to bail, is what we are challenged with as it relates to the Constitution and due process. The case dealing with United States versus Salerno. I'm going to paraphrase this because I could read the whole case, but that just bore you to death. But what it deals with, and I prayerfully as I present it to you, you can understand where we are. We're dealing with Salerno, who was a mafia boss. Of course, he was arrested, brought before the judge, and the judge denied him bail. So therefore, he filed on the grounds that this is in violation of his constitutional right. All of us deserve to be placed on bail. So he filed the case and went on up. He went before the different courts. And so therefore, he was given his rights. All of this was given his rights. Obviously had a lawyer. He went before the court to have his bond reconsidered. And the government, what the case says, the government, because of the charge of the mafia boss and the racketeering and the fact that the government established that he was a risk, a flight risk, and that he also was a danger to society. So the government, of course, had to, because he had what we call an adversarial hearing, where reconsideration of his bond was in stake here. He had the hearing. Long story short, the government supported his theory, or their theory, as it relates to not allowing this person to be let out on bond. Went all the way up to the Supreme Court. The Supreme Court affirms that decision not to, because of what I just said. The hearing was held, and they proved, I guess, like I said, to the court, that this person is a risk. What we're looking at here is liberty, the Constitution. We have a right. This person has not been convicted of anything. So the question is he being held in jail as punishment without even being convicted, tried? That's the case. That was the whole argument that he had as it relates to being in violation of his constitutional right. But what the case end up is saying, what the Supreme Court says, we have safety for the community and flight risk opposed to liberty. In this case, safety and flight risk took precedent. The Supreme Court stood on that. Now, the other case, Stack and Boyle, totally just opposite. They were involved, these were promoting communism, called it the Smith Act back in the 1940s. Anyway, so they were arrested. Originally, a first bond hearing they went to. Some of them was charged at $2,500, the other $7,500, the other $10,000, up to $100,000. So they went before the bond hearing court, and they went to another court, that is, in this particular, as they appeal their case, because of the one court says, when we come to our court, for example, the summary court, and there's something that we may have messed up, or we think we messed up, and we go to another court, they have some option to do that's a higher court, what they want to do. So the higher court set their bail, said, no, because we had a similar case to this back in New York. Those persons were they're bonded on, were released on $2,500. These are surety bond, $2,500, $7,500, whatever. They were released, and they forfeited their bond. They never showed up for court. So here, California has the similar situation. Well, New York had a similar situation. Their lower bond, and they forfeit. They didn't show up for court. So what we're going to do, we're going to up their bonds to $50,000. With that, the plaintiff or the defendant says, well, that's excessive bail. And I mind you that now the case, that if any one of them were found guilty, the max was $5,000, 5 years in jail rather, and $10,000 bond if they were found guilty. But yet this case, this court, another jurisdiction, $50,000. So again, they appeal. And to make a long story short, when you show the only reason California says $50,000 as opposed to what was done in the other jurisdictions, because those persons forfeited their bond. They had no other reason. These were a different scenario. So we're treating these individuals without even going through the process of, well, John Doe, no matter how we could be in a group, but when we look at signing bond or placing bond, we have to look at the individuals. In this case, they didn't do that. They just look at them as a group. as opposed to individual. And this is where the violation comes in, that they're violating their constitutional right by excessive bail. And so when we are challenged in the courts, when we see what's happening in front of us, when we look at what's all is going on now, when we look at these cases that has been established some years ago, and we see some of the challenges that we have in court today as it relates to, well, I'm gonna say something. You may say that this has nothing to do with it, but when we, it's about making sure that each person's constitutional right is protected under the due process clause of our Constitution, especially the Fourth Amendment. We see in these two scenarios where the government, yes, had substantial reason to not place bond because they based their finding on facts, rather than in the Ball case, they only did it because they saw a similar, had nothing to do with the individual. That was a clear violation of that person, of those persons who filed a constitutional right. Yeah, this was some time ago, but today, as we, as judges, magistrates, municipal judges, have individual comes before us, what it does in reading these cases is to make sure that we apply the due process clause. Make sure we know. A lot of times, if we talk and you hear about a person being incarcerated for lower level offenses without even considering the person's record. Is this person a flight risk? Is this person a danger to society? Because the Constitution, and if you read the law, it's always assumed that every person shall be placed on a personal recognizance, except the court finds out differently. Is this person a flight risk? What I'm saying, you always, the law always assumes that, you could be placed on a personal recognizance because it should not be held as punishment pre-trial. That's not that's not the purpose of the bond hearing court. But a lot of times we use it as a means of incarcerating people or keep them in jail pre-trial without due process. I think it's appropriate for me to say this. We got a mandate the other day, a memorandum from the Chief Justice, and we, as it relates to something that was happening in our courts for some time. In other words, we were putting people in jail without giving them their constitutional right. Most of these folks are people, a person we TI tried in their absence. They never appeared before courts. I know there's some exception to these. Never appeared before our courts. So what we do, we send them a letter. If they have court today, we'll send them a letter, say, okay, and they didn't show up. Well, John Doe, you were supposed to be in court today. You didn't show. Trial went on. Your absence. What we do, we send them a letter, tell them those facts. Now, you have 15 days to take care of this matter. If not, a bench warrant will be issued against you. So if they don't take care of it in 15 days, the bench warrant is now issued. Person is eventually arrested. Well, $200 or 30 days in jail. What the Chief Justice is saying and what the law says that we're doing, we're in essence sending that person to jail without due process. That person has never appeared before the court. That person was never apprised of their constitutional right to have an attorney present, that if they cannot afford one, that one will be appointed. That's the violation. That's why you hear, that's why there's it's a lot of uneasiness going around as it relates to this mandate and order. This was reaffirmed. We had a class, we had a meeting on November 1st in Columbia, re-emphasized. So as Chief Judge of Charleston County, what I've done now is send out an order asking each court to recall all of their bench warrant. Now, they're not going to be dismissed. We're violating these people's right by doing what we've been doing. All the Chief Justice is saying to us, bring them back in through a process. Make sure they have their rights. It's the Sixth Amendment of the Constitution. That's what we have to do. And there's a process. For example, there's a process to that. If they don't come first time, you got to do it again. And they're coming out now. Let me tell you, if you have given them 2 notices and they don't show, they're coming out with a bench warrant. We'll have it on the end of the month. The bench warrant currently says you take this person and you lock them up in jail pending whatever, until the person pays. You put them in jail. The new bench warrant is going to say, if that person, you arrest this person, you bring that person before the judge so that he can be apprised. That is now if you plan on sending the person to jail. Now, if it's just a fine, fine. You don't have to do anything. But when you give that option, going to jail or pay the fine, you must have that person in your presence. That person must be afforded that right before you can send them to jail. If you do that without doing that, then you're in contrary to the law. So that's what is going to happen. We're going to readdress, and they talk about, there's some, how about the victims? Well, you show me some cases where the victim's going to be involved in these cases, and then we'll deal with that separately. But the victim must be informed. If there's a victim involved in any one of these cases, they have to be informed. That's constitutional. We got to do that. But that is how we address, and just new mandate. We're talking about jail reform. We're talking about, there are a lot of low-level offenders that are in jail that shouldn't be in jail. That's what we're talking about. And I thought it was appropriate for me to make this statement while I'm up here. I think there was something else I was supposed to be talking about. Well, I think I've already said that. I think as far as being able, what's our authority as far as setting bond, setting bail? Yes, we can, and there are exceptions, and I gave that to you as far as life in prison and murder, and there are some exceptions when it comes to the violent crime. That is section 16(1)-60. It tells us, and that's our option. We can set bond on those other offenses. But if we choose to send it up and let the circuit court do it, we can. Now there are, of course, if we set bond, if bond is set on the defendant and he's out of jail and he commits another violent offense, well, that doesn't come before us. That has to go before the circuit court judge. That is if that offense does not incorporate any of the one he or she are currently out for. So, again, that's our responsibility. That's what we try to. We're educating our judges every day about being aware. Everything we do, we have some directive in front of us. The bond hearing court judge have directive as to how these things are done, and we try everything we can to make sure the rights of those defendants are given and afforded so that they can know. And sometimes I say this to you that sometimes you can read off their rights, you can give them documents to sign the way we do now, but sometimes they're so caught up in where they are. Do they realize what they're signing? Or they realize they're signing off their constitutional right? They realize that they have a right to have an attorney. They can't afford them. There are a lot of things that are said during that hearing. But some of these things, because of where they are, and I think what it is here, I know there are some who would say, well, you can't baby them, you can't pacify. But I think it's important that everybody, because a lot of us, we don't have the same understanding, and it's so important, the Constitution, the least of us, that everybody understand what their rights are. Sometimes you have to just walk them through it, as opposed to just reading it off on some paper. So I think what the Chief Justice is saying to us, that's what we need to do, because a lot of these folks, affects, some poor people, and that really doesn't have sometimes the kind of education that would understand what their rights are. And I think the bottom line is for us to do everything we can to make sure that you do understand their right. And I applaud everything that is happening here in CJCC as we try to just do things differently, because we know that there are so many folks who are affected by not understanding. There are so many folks, for example, understand that TIA, they didn't come to court. I didn't come to court. I didn't have the money. I was afraid I might be locked up. Not understanding. They could come to court and be placed on a time payment. You see what I'm saying? When they come, you're on a time payment. You don't have to pay it all if you don't have it. And in the statute, in the 14th Amendment, 6th Amendment, 8th Amendment, 5th, excessive fines. We want to put the maximum fine. It says in there, why can't we just give the lowest fines possible? A lot of these folks can't afford it. They're working every day, trying to make ends meet, and they get caught up in something, or maybe they're changes their lifestyle, and now they got a job, and they're arrested because they owe $129. They lose their job. What happens there? They're demoralized. They just go ahead and do whatever they need to do to survive. So it's collateral damage in a lot of ways when a person doesn't know. So I pray that what I've said here today would help in some way. Thank you.